Mr. Tinker. Good morning, Mr. Tinker. And Ms. Lee, I see you. Excellent. You both are here. Mr. Tinker, you are unmuted and you're ready to proceed. You have 20 minutes, as you know. Would you like to save any time for rebuttal, sir?
Yes, Your Honor. I'd like to save 5 minutes, please.
Very good, sir. You may proceed, sir.
Good morning. May it please the court. Mark Tinker on behalf of Bradenton PC Investors, Palm Cove Condo Association, and RAM Partners. And before I get started, I would like to say, for some reason during the last argument, my internet dropped twice. I got back in and it seems to be stable now, but I apologize in advance if it happens again. So hopefully it does not.
No problem, Mr. Tinker, and we do the best. And I think our marshal explained to you there's a number. We will find you. We will make sure that you get to be heard, and we'll make sure that we'll proceed with this. So no worries about that.
I appreciate that. Your Honors, I think on the main issue, which is the apportionment issue and whether the proposals for settlement, this judgment can trigger the proposals for settlement, the key to that is that this is a burden of proof issue. As the party seeking to enforce the proposals to recover, to gain entitlement to attorney's fees, Jones has the burden of proving that the judgment obtained triggers these proposals. And the concern here is prior to trial, these three defendants objected to them being placed together on the verdict form. There was a whole dispute as to whether there were non-delegable duties owed that would make them all jointly and severally liable. The three defendants said, no, those do not apply. This is not a non-delegable duty situation. They can't be placed together on the verdict form. They were placed together on the verdict form. We have one joint verdict. And the issue is that leaves Jones incapable of determining whether the proposals actually triggered or whether the judgment actually triggered any of the proposals. And I know, the arguments have been made, well, this is something that if you had an issue with the way that this judgment turned out or with the way the verdict form was and what led to the judgment, then we should have done something about it post-trial. We should have asked for a new trial. We should have appealed. We should have done any of those things. And that, I think, twists the burden of proof. Because otherwise, these defendants are okay with the verdict. They're okay with the trial result. I know we don't have a complete record of the trial, so I don't have what the demand was, but what is in the record shows that there were about $600,000 worth of medical bills alone claimed. The verdict came in at $90,000, so less than 1/6 of what was just in the medical bills. This litigation, it involves a slip and fall that occurred 7 years ago. At some point, parties can look at it and say, we are through with litigation, enough is enough over this. This litigation is, and I'll call it, I think, oddly contentious. If you take a look through the record, when I was looking back through it, I counted 16 filings coming from Jones that had sanctions requested in them, whether they were discovery sanctions, 57-105 sanctions. There was a motion saying that there was fraud on the court that had occurred over discovery. So it's litigation that involved punitive damage claim and all the discovery that goes along with that against parties that was eventually dropped. But the inconvenience of having to turn over financial worth discovery and everything that goes along with it. So these are defendants that don't want a new trial. They are okay with the verdict as it came in. And the suggestion that it would be our burden to either ask for a new trial or come here, and I would be here on appeal of the final judgment right now, asking you to give me a new trial I don't want for the sole purpose of going back and getting an apportionment of damages to try to disprove their entitlement to fees. That is not the way that the burden of proof works. The Florida Supreme Court's made it very clear that the party seeking fees has the burden of proving their entitlement. So we objected to the verdict form being this way. We objected to being lumped together as a jointly and severally liable parties. But that is what the plaintiff wanted. That's what Jones wanted. That's what she got. And she's rendered herself incapable of showing that she has a valid judgment against any of these individual parties that received a proposal for settlement, that she could trigger that proposal for settlement as to any of the three.
But Mr. Tinker, if I may, Mr. Tinker, that's all well and good. And I think with your clients, they were in a precarious position. They liked the judgment, considering what their exposure is. But if they take issue with something on the verdict, shouldn't they have appealed it at that time? I realize now because of fees, they're making that argument. But if there's some concern with the actual the judgment, why isn't Ms. Lee's argument well taken that your client should have appealed? I realize all the economics, I realize all that, but let's look at legally, based on the case law of taking issue with what's the final judgment. Why is that not well taken?
Because we'd have to have a case or controversy to come to you with. If we were to file an appeal, we would need to have a harm that we're asking you to redress. And we don't want, we'd be coming to you asking for a new trial that we don't want. The judgment itself does not harm my clients. They were okay with it. They're fine with the judgment. The harm comes in a collateral proceeding post-trial when Jones tries to enforce her proposals for settlement, which now is, like I said, it's a collateral proceeding. It's now her burden. And if she has something.
If I may, Mr. Tinker, the proposal for settlements are there. They're in the case prior to the judgment being entered. So that was there. Your clients were aware of that. And if you take issue with the judgment, it was very clear. You're taking the position, you objected to the verdict form, you objected to that. You're taking the same position now that maybe you made the argument back then. It should be delineated. You can't really wait till after all of that and not appeal that, knowing that that's the exposure is that, and to wait at this point in time. So I'm trying to find out, why isn't the issue that it should have been appealed at that time well taken?
Well, two things. One is it's not knowing that that's the exposure, because that's why we're here now, is that we believe that the judgment as rendered leaves Jones incapable of triggering her proposals, because she does not have an inherently valid judgment as to any of these three defendants that could trigger the proposal. So there was nothing to do at that point. And I think the second issue is, this is kind of similar to what I already said, but I can't emphasize it enough, is that this isn't something where it could be appealed and it's a simple mathematical correction or a clerical correction that could take place. It would have to go back for an entirely new trial to have a new jury reassess everything and reapportion. So that is something that we'd be asking the court to give us something we don't want over a judgment that we believe is invalid to trigger any of the proposals. So there's no harm until the judge says that all of a sudden this judgment is valid to trigger it. And the one thing that I think,
Mr. Tinker, I think the problem with your argument is the judgment. You can't say the judgment is invalid for these purposes, but a valid judgment. I don't think pursuant to the statute, pursuant to case law, we look at the proposals for settlement and we look at the judgment, and that's the judgment that there is. That's what we have before us. So to start saying, well, it's invalid to this extent, but it's valid, but we don't want to challenge it.
it's in
where's the authority for us to start parsing what's valid about this judgment and what's not, when you're not actually challenging the judgment?
Well, the invalidity of it is that it's invalid to be able to show how much was attributable to each defendant. So it's a valid judgment in general. It's collectible. It's a judgment. It, could be recorded and collected, but it does not show. It does not satisfy the burden of being able to show how much is attributed to each defendant that received their own individual proposals for settlement.
But it doesn't Anderson make clear that doesn't matter?
It doesn't. And Anderson, the big difference in Anderson is the parties all agreed that the three defendants in that case were all one and the same. They didn't even refer to them by parties' names. They called them Embassy Suites, which was just the trade name that Hilton was operating under for that property. So they all agreed that they were going to be joint and several. They agreed you could call them Embassy Suites prior to trial. At trial, the judge said the parties have agreed this is just Embassy Suites, treat them one and the same. The judgment that was rendered in that case was rendered as these three collectively hereinafter referred to as Embassy Suites. Everybody agreed they were all one and the same there.
But it doesn't seem to me though that Anderson relied on that in its holding when it said nothing in the offer of judgment, statute, or rule requires a plaintiff to obtain a judgment against a specific defendant where there are multiple parties to the action. So the court wasn't relying on the fact that that they were all Embassy Suites. The court was saying, you look at the rule, you look at the statute, this is what it says.
And what I would say to that is there are situations, and the big one, I'll say the Florida Supreme Court's kind of seminal decision, Attorney's Title versus Gorka. That is the case where you have a proposal or an offer of judgment that is sent to two parties. jointly and saying that you both have to accept it. The Supreme Court said you can't do that because it deprives each party of the individual ability to accept or reject. The statute 768.79 doesn't say that. 1.442 doesn't say you have to do that. The Supreme Court said that's inherent, that you have to give the parties the independent ability to accept or reject. They just read that into it and said that's inherent in it. This is no different, because inherent in being able to trigger your proposal is you have to have a valid judgment as to these individual defendants. If they, over objections, got a judgment that does not properly apportion as to the parties they want to try to enforce their proposals against, inherently they have an invalid judgment for purposes of enforcing the proposals. It's a valid judgment. To your question earlier, it's a valid judgment. It's invalid to carry their burden of showing that they got enough to trigger each of those individual 3 proposals, or any one of the 3 or combination of the 3. So it's invalid for that purpose, because they argued that they wanted it jointly. So they rendered themselves incapable of taking that otherwise valid judgment and using it to trigger these individual proposals. That's why Anderson is different, because everyone agreed that it was okay for that purpose.
But Mr. Tinker, if I may, I guess it's almost like a circular argument, because now we have to assume right now, based on the fact that the prior judgment was not appealed, that we do have a valid judgment. There's a judgment. That's a judgment that right now we are operating on. We have Anderson that says if you lump 3 people together, it's appropriate. So you have a case that says that's okay. And then you have a valid judgment. And in our case here, you have appropriate offer of judgment that being submitted to the separate individuals, delineating, hey, each of them that does not violate, the rules. So I guess my question is, you can't have it both ways. You can't just say, oh, it's a valid judgment, it's an invalid judgment for purposes of the offer of judgment, that it's an invalid judgment because we objected to, but even though you did not appeal it. So I guess what I'm trying to say, Anderson says it's okay. It's okay to have these people not delineated, and it's okay for purpose of the offer of judgment rule. So that's where I'm struggling to understand your argument, sir.
And that's where I would just say it goes back to the beginning, is the burden of proof issue. Is they have a valid judgment. They got their piece of paper, but their burden of proof is to have a judgment in a form that would allow them to show that they've triggered their proposals. And if each of the liabilities are all different as to these defendants, and they didn't get a judgment that shows what each defendant's liability was, they got them all lumped together to where they can't tell and nobody can tell, then they didn't obtain a judgment that's sufficient to carry their burden of proving their entitlement to fees. So I think that's where I was going with the attorney settle versus Gorka, is that inherent in the statute of having a judgment obtained is that it's a valid judgment obtained for that purpose of showing that you've triggered the proposals. You can get a judgment against any group of people for a gigantic amount and not have something that you can show how much was attributable to each person that you sent a proposal to. So that's where we believe it's different from Anderson, because in Anderson, they agreed that it was lumped together, that everybody shared, that it was all the entities were, that the term that the opinion used was one and the same. There was only really one entity. They were embassy suites. So that they agreed everything was together. And so the court said, well, there's nothing to do other than look at the pure math of it. Here it's different because they're not one and the same. They don't have the same liabilities. Jones obtained a judgment that she can't use in order to trigger her proposals.
But as a practical matter, they do have the same liabilities because it's joint and several, right? So each one of them could be liable up to the entire amount.
And that's where they shouldn't be joint and several. And that's where it would we're running back into the burden of proof again, because we'd have the judgment. We believe it's incorrect. It shouldn't be joint and several, but that would leave us in the position of having to appeal for the sole purpose of disproving their entitlement to fees.
And I understand that. I understand that it's a difficult position, but as Judge Kuzam said, you can't have it both ways.
And that's where I think it's not having it both ways. It's the way that you have to look at the burden of proof. It could go either way, where I have the judgment, it is insufficient to trigger fees, We don't have any reason to appeal it other than try and disprove their entitlement to fees. So you look at the burden of proof is theirs. It shouldn't be our burden to appeal it to show that they don't get fees. It's their burden to get a valid judgment to begin with to show that they are entitled to fees.
And
So
Mr.
that's what
Tinker, maybe this is a good time. You're about to get into your rebuttal time. Do you wish to go forward or do you wish to reserve the remaining?
I'll reserve. The second issue has to do with the amended complaint, and I'm content to rely on the briefs for that. I'll just reserve my time unless you have any questions about that issue.
Well, I did have a question on that.
Yes, Ron.
So your position on the second argument is that because when they were given notice of what they were making a decision about, so each of these parties got one for $75,000, and the thought is I have to decide right now for me as this entity, do I settle this for $75,000? And it was based on what had been claimed at the time. I understand punitive damages were added and then taken off the table later. But there was a substantive amendment made at a later date. Is that correct?
Yes.
So was there ever any indication or any consent that the old offer of judgment should still stand? Or I guess the plaintiff's petition is not a substantive change. But what's your position on that?
Well, that's, and this is, I guess, the flip side of the coin, Your Honor, is, my last argument was you have to look at what's inherent in the rule. And if we're going to, instead say you have to go with strict construction of the rules, what the rules say is when there's an amended pleading, that supersedes the prior pleading unless any portion of it is expressly carried over. And here we have a pleading that's in place. We have proposals that are sent that talk about the claims in the lawsuit, and they specifically reference claims, and these are quotes, currently pled and currently pending. So they're referring to the current complaint, and then after those proposals expire, the complaint is amended with no reference to carrying anything over. So by rule, and this I know in the briefs there are a couple cases from this court, Metro Bank versus Vanguard and Eigen versus Federal Deposit or FDIC, that say no part of it, if it does not express an intention to save any portion of it, the amended complaint supersedes the prior one, and the allegations of the initial complaint become irrelevant. So we have a pleading that the proposals reference that now has been superseded, no part of it saved, and there's a new pleading in place. So that is our argument. If you're going to look at a strict construction of the rules, the proposals referenced a document that is void, essentially. It no longer exists. No part of it was carried over. If they wanted to amend to add these new claims against RAM partners, they could have kept their complaint and said, we want to save everything. We're going to add these new claims. They didn't. They replaced everything and changed some allegations in the process. So that is the issue with that. And I hope that answers your question, Your Honor.
Thank you.
Actually, Mr. Tinker, you have 2 minutes left for rebuttal. I'm going to reserve you that time. Okay? Very good. All right, Ms. Lee, you may proceed, ma'am.
I need to check my microphone. Am I working?
Yes, you're working just fine. We can hear you fine. Thank you, ma'am.
Good morning. May it please the court. My name is Catherine Lee, and I represent the appellee, Barbara Sue Jones, who is the plaintiff below. This court's already focused on the major point that I need to make today, that the question that is on this appeal focuses only on 2 words, judgment obtained. That's a very narrow issue that's in play. It's simply a question of entitlement to fees under the proposal for settlement rules and statute. It's a question of the judgment, not the verdict. The only thing that is compared to the proposal for settlement is the numeric judgment obtained. As I discuss in my brief, and I'll address a little more later, it's a mathematical analysis. It is literally, once the judgment is final, as it is in this case, it's compared to the number in the proposal for settlement, and you check if it's 125% of the proposal, and if so, that meets the burden of proof to get entitlement to fees. That means any arguments about whether the complaint was amended after the service of the proposals for settlement doesn't affect the question of entitlement to fees, because the exact—
I have a question on Rule 1.442. Under 2A, it says the proposal shall name the party or parties making the proposal and the party or parties to whom the proposal is being made. So did not your client make a choice to do 3 individual requests of $75,000 and state that if you want to be released individually, that you'll do the 75,000?
Yes, Your Honor, we did. And the rules and the statute allow us to do that.
Right. But then whenever you did the verdict form, you combined all three, which I know Anderson will have to talk about. Anderson
addresses that directly, but it should also be noted that in the original complaint and the amended complaint, both pled that each of these three defendants had a non-delegable duty. They were on notice that we were claiming a non-delegable duty, which is supported under significant court precedent, that this judgment should have been entered joint and severally against all three of these defendants. And they knew that going in. At the time the proposals were served, they knew each defendant separately got a proposal served to them that allowed them to consider their own individual exposure. The fact that they were all represented by the same counsel doesn't change that analysis as to each defendant. So when the proposals were served, they knew what we were claiming, they knew what we were pursuing.
If one had paid the $75,000 and said, that's it, we're good, is it your position that there was still $150,000 worth out there? Because the offer itself says that only releases you.
It does. And the rule and the statute allows us to do that. That is one of those things in the statute. And as this court made clear in Hesse Walton, we would be remiss if we did not use the statute to our strategic advantage. The proposal for settlement statute does have conditions in it that sometimes run to the benefit of the plaintiff, sometimes they run to the benefit of the defendant. But the point is, it is a derogation of common law and it should be strictly interpreted. The statute allows the plaintiff in this case to serve three separate proposals, and we did that. There is no reason to add new terms to the statute to invalidate that entitlement that after that mathematical analysis, because the total amount might have been different. That was what the Supreme Court quoted at length in Anderson v. Hilton Hotels from Hesse v. Walton, where it explained that if one defendant settles, sometimes that changes the entire strategic planning towards trial. And proposals for settlement are often served as volleys, like to begin the discussion of settlement. And oftentimes in my office, if we serve three proposals like that, sometimes we get one back that says, or we get a call from defense attorney that says we will settle. It's a starting point to discuss settlement with some teeth behind it under the terms of the statute that all parties are aware of those terms at the time the proposal is served. And that is what was enforced. The damages we were seeking at the time the proposals were served were the damages awarded by the jury. At least, I mean, we can argue whether or not it applies to RAM Partners, but it definitely applies to Bradenton PC Investors and Palm Cove Condominium Association. Neither of those two defendants ever had punitive damages assessed or brought against them. None of the defendants had it assessed against them. So plaintiff's entitlement to fees under the proposal for settlement statute and rule also flows from her proposals for settlement to Bradenton PC Investors and Palm Cove.
Can you explain for me why the amended complaint, your position is that the amended complaint is of no issue here?
It's because punitive damages were not included in the judgment obtained. The only case that actually addresses the issue of whether or not judgment obtained needs to parse out punitive damages versus compensatory damages is the Palmentier Brothers case.
Were punitive damages the only change in your amended complaint?
Absolutely, 100%, Your Honor. The only change, there was one paragraph that added, I detail it like down to the paragraph in my brief, and I honestly cannot remember the paragraph numbers right now, but there was a paragraph against RAM Partners that added allegations of gross negligence, and then the wherefore clause added and seeks punitive damages. That was the only change. The duties alleged against any of the three defendants who are now appellants did not change. The breaches of duty did not change. The damages sought against Bradenton PC Investors and Palm Cove did not change. Ultimately, what was awarded in the judgment did not change because through the contentious discovery, we learned that the factual basis for punitive damages actually didn't exist. So that Palmentier Brothers points out that it's a comparison of apples to oranges, that at the time a proposal is served, it's unfair to create entitlement when the proposal itself disclaims punitive damages. It would be unfair to apply that proposal to a verdict that is primarily punitive damages. That simply did not happen here. The proposal for settlement in this case sought to resolve all damages that could be awarded in a final judgment against this defendant. It complied with the statute. Defendants are not arguing that our proposals did not comply with the statute. We've met all the statutory preconditions. They're not arguing that the proposal was ambiguous. They are simply challenging the form of the judgment, which is what Judge Kuzan pointed out earlier, is that Anderson says it is the judgment obtained. If you look at subsection 1 of the statute, it actually says a judgment obtained. It doesn't matter who we get the judgment from. It's the amount of the judgment compared to the amount of the proposal that triggers entitlement, and that is a mathematical analysis. The number of cases.
So your position is you have 3 parties. One of them's a homeowners association, may have more or less, without getting into the relative parties' responsibilities, but their position is we only have this limited amount of liability and there's no way to apportion it in the verdict. Your position is you lump it all together, and even though they had a small responsibility because they didn't step up with the demand for $75,000 versus $225 if you triple it for each of the parties. So if any one of them get a judge, the judgment comes back, they're responsible for the attorney's fees. I just want to make sure I'm understanding your argument.
My argument is the plaintiff has met her burden of proof under the proposal for settlement statute, and it is a mathematical analysis. We have that judgment obtained. But your question where it addresses small bits of liability forgets that this is a premises liability case. And in premises liability cases, it is clear under this court's holdings, it was not cited in the briefing because it wasn't at issue. In Metzger versus Carefree Scott and Cook versus Bay Area Renaissance Festival, or Largo, it became Bay Area, that when you have a premises liability case, you can have concurrent duties. There can be 3 layers of entities that all owe a duty to maintain the premises. And that's what happened here. We had a property owner, a condo association that had responsibility for the common areas, and then a management company that had contracted with both of them, and their duties all overlapped. The source of their duties might have been different. Opposing counsel brought that out in the briefing, that the source of the duties had different statutory bases, but they were concurrent and they stacked on top of each other. That is not something that a jury would apportion, like if you have joint tortfeasors. They're not joint tortfeasors. They all owe a non-delegable duty, and that stacks on top of each other. And that was alleged in the complaint at the beginning, and that was in place at the time the proposals for settlement were served. And the defendants, when they received those proposals for settlement, had the opportunity and ability to consider their individual potential exposure and decide whether or not to settle the case. Numerically, the judgment obtained in this case was $97,200. That is 125% of any one of the proposals. So let's take Bradenton PC Investors. That's the landowner. Plaintiff served a proposal for settlement for $75,000 to Bradenton PC, and plaintiff obtained a judgment for in excess of $125,000 or 125% against that defendant. That defendant was jointly and severally responsible for the entire amount of the judgment. And had we actually added the costs up to the point of the proposal, as we were allowed to do under White v. Steak and Ale, that number would have been even higher, but at the trial level, nobody needed to do that because everybody conceded that the numbers were met at the time the judgment was entered. It's only after the fact that now the judgment is being contested on a burden of proof argument that doesn't exist. The burden of proof is stated in the statute. If you meet the requirements for things like ambiguity and timing, which are not at issue here, if numerically your judgment against anybody, as said in Anderson, if your judgment exceeds the proposal by 125%, then you are entitled to fees and costs. The plaintiff has met that in this case. Therefore, the trial court did it correctly. If the issue is with the judgment, that it should not have been joint and several, that's a very, very, very different argument on appeal, and that judgment should have been challenged when the first judgment was entered or when the amended judgment was entered that added costs jointly and severally against everybody there. The fact that
let me, because I know I want to be able to ask you a question regarding the rent partners. Mr. Tinker raised the issue that you did file an amended complaint, and I know you mentioned punitive damage with respect to rent partners, but then your clients withdrew that right before trial. I want you to take a few minutes to address, you're taking the position that that really should not have affected the proposal of judgment with respect to rent partners. Focus that, eliminate the other two, but focus on that and tell me your position with respect to that issue.
So what Your Honor is asking is why the fact that punitive damages were added and then withdrawn against rent partners does not change the result of this appeal.
Given the fact that with respect to, offer of settlements, proposal for settlement, that it deals with the current, complaint at issue. So I want you to be able to address that for me.
Okay, first, the proposal for settlement statute does not tie a proposal to any particular pleading at all. There's nothing in the statute that says that. There's nothing in the rule that requires that. The language in the particular proposals that were served in this case said that it was all damages that could be recovered. Now, the language that counsel has cited, the currently pled or currently pled in this complaint, actually described what was not pled. It's the requirements in Rule 1442 where we have to say whether or not any part is allocated to fees or to punitive damages. When those proposals were settled for settlement were served, neither of those were pending, so they were not currently pending in the complaint. We move forward with that. Now, the other thing is that punitive damages were, at the time the proposal was served, were not pending. They were pled after some discovery revealed that we thought there were some things that amounted to gross negligence. After punitive damages were permitted and discovery went a little deeper, we learned that that factual background, that factual basis did not exist at all. Therefore, we withdrew it, did not move forward at trial because continued discovery showed that we would not be able to prove that. And that's exactly what discovery is supposed to do. And we move forward with that. The issue is, I don't want to say that Palmentier is inappropriately decided, but there's a disjunct between Frosty v. Creel and Palmentier brothers, where Frosty v. Creel, the Supreme Court said that the amount of the judgment obtained. In that case, it is slightly distinguishable, and Palmentier brothers analyzed it differently because in Frosty v. Creel, punitive damages were addressed in the proposal.
And if I may, Ms. as I read these cases, I try to synthesize the law should make sense. And the whole purpose behind a proposal of settlement is to try to encourage folks to settle. And as I read these cases, correct me if I'm wrong, where the issue of punitive damages come in that may make it problematic, if you have an offer of judgment, like in yours, for instance, that excludes, it excludes punitive damages, it excludes all that. So if later on there's a claim for punitive damage added, it renders that offer of judgment vague. What does that mean? You have a pending offer of judgment that has a certain amount that did not include punitive damages. Now you have a punitive damage claim in a case. And as I read those cases, say, because it renders then the whole offer of judgment ambiguous, that's what becomes problematic. And as I understand your argument here, is that in this case, you have an offer of judgment that did not include punitive damages, very clear. Then with respect to rent partners, ultimately your client decided to file a claim for punitive damage, but then withdrew it. So therefore, you're taking the position it does not render the initial one ambiguous because the issue of punitive damage is non-existing. Is that in a nutshell what you're trying to argue?
That is the practical result of it. And it's based in the language of the statute, where the proposal for settlement statute is designed to resolve all damages that can be awarded in a judgment. And that's what was awarded, and that's what the judgment obtained is testing against. In Palmentier Brothers, it was only that the punitive damages that were added and awarded after the proposal for settlement was served and expired is what kicked it over to trigger entitlement. That's not the case here. The damages being tested, the damages awarded by the jury and included in the judgment obtained are the same damages that were pending at the time the proposal for settlement was served. So given the fact
that I've been looking from what you said earlier, that as far as it just being the punitive damages, and I went back and looked, so there were some, what I think are substantive changes in that amended complaint. So when they dropped the punitive damages, did they go back to the original complaint, or that's what they proceeded to trial on? They completely changed the description of what the responsibility of RAM partners, instead of just being about the wet paint, it went into the overall maintenance, safe condition, etc.
Those issues were actually a description of the standard and practice that came from expert testimony. Those were the sources of the duty. The duty still was to maintain and warn. So the complaint did not actually plead those things. Those were things that were described in the jury instructions after expert testimony.
No, the amended complaint changed the wording. I mean, I will go back and look at it, but it looks like the amended complaint was changed, and the offer of judgment, the proposals for settlement allows you to go back in. I mean, wouldn't your responsibility then to have just been to send another one out based upon the amended complaint and make sure the parties knew what the changes were and what the responsibilities were?
At first, the statute doesn't require that. There is nothing in the statute that ties a proposal for settlement to a particular complaint.
No, but it says you have to allege it with specificity. If you amend the complaint and go to trial and get a judgment on that amended complaint, then it's different than what you originally had offered to settle for. So what it allows you to do is come back in as you amend your complaint and make sure that they have another opportunity. They now know the new things that you're alleging, and they have a chance to step forward based on those allegations.
Okay. I've pulled up the amended complaint as compared to the original complaint, and the only new paragraph in that complaint was paragraph 68. And it's alleged that defendant Ram's failure to maintain the premises, including the space immediately outside the plaintiff's front door, in a reasonably safe condition, especially in light of knowledge of the danger of wet paint, was so reckless or wanting in care that it constitutes a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct.
Okay, and what did the original one have?
That paragraph did not exist. It merely alleged that they breached the duty to warn and the duty to maintain.
Right. So it was well, I guess the question is it a substantive difference in what?
I drafted the complaint. I drafted the amended complaint. It was an allegation that described that we thought at the time we made the allegation that it rose to the level of gross negligence.
And Ms. Lee, I know you ran out of time, but I want to make sure that you're able to respond to Judge Stargill's question, because the 20 minutes go quickly around here. So if you want to take just 10 seconds to either, or I want to make sure.
My question's answered. I mean, she just answered what she believes.
Okay.
I'm fine with moving on.
All right. If you want to just take 10 seconds to wrap it up, Ms. Lee, because you are right out of time. You did run out of time.
My is that the trial judge correctly did the math between the judgment obtained and the proposal for settlement against any one of the three separate appellants, and therefore the judgment should be upheld.
Very good. Thank you, Ms. Lee. I'm going to ask you now to mute your microphone. Mr. Tinker, you have 2 minutes for rebuttal, sir.
Thank you, Your Honor. I'm going to try not to avoid repeating, so I'd more like to address any questions that the court has. But I think, one of the issues that was just brought up as far as the amendment with RAM Partners really kind of highlights one of the problems here. If there's an issue with RAM Partners as far as the punitives being added and allegations added and an amendment taking place and then being taken back out, that really infects everything because of the form of the verdict and the form of the judgment that Jones received. Because now we have, if we say the proposal could be invalid as to RAM Partners, how do we know where the jury put the liability? How do we know that the jury put the liability on anyone other than RAM Partners? So Jones does not have that ability to show that the verdict that she obtained is sufficient to trigger these proposals. And I think really, that goes to having it be an inherently valid judgment that is obtained for these purposes. If we say that, we assume this judgment has a problem, it has an apportionment issue. Is it our burden, if we have a judgment with an apportionment issue, to appeal it and do something about that if we're happy with it, if we don't otherwise have any reason to ask for a new trial? Or is it Jones' burden, if she wants to take that judgment after serving individual proposals on each of these three, wants to take that judgment and use it to trigger those proposals to show that it's sufficient to do so as to any one of them? And without doing that, what it creates is this situation where they've served three proposals, $75,000 each. So it's a total of $225,000. They get a judgment for $97,000 and can look to each individual one and say, RAM Partners, you owe me fees. Bradenton, you owe me fees. Palm Cove, you owe me fees. Because they have this joint judgment that shouldn't be there and is not sufficient to show that they triggered those three individual proposals that they served. So I think, like I said at the beginning, it's a burden of proof issue, and now I am repeating myself, so unless you have any questions.
Actually, you're perfect timing because you just exhausted your rebuttal. Thank you both.